Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam. I'm Jana, Seidl, and the title of today's episode is No Nonsense or Nonstarter, the FTC's proposed rule to ban non-compete clauses. So in January 2023, the FTC issued a Notice of Proposed Rulemaking that would ban virtually all non-compete agreements between employers and workers, and that's both retroactively and going forward, categorizing them as an unfair method of competition under Section 5 of the FTC Act. So that issuance came just one day after the FTC announced its first settlements with employers, alleging that their non-compete clauses were unfair methods of competition. Non-compete agreements, of course, have existed for at least a century, and the FTC estimates that non-compete agreements exist in about 1 in 5 employment agreements in America today. That topic also came up at the State of the Union recently, where President Biden brought it up as an important issue. As we speak with Anna Aryankalayil, partner at Orrick, Herrington, and Sutcliffe in their DC office, we address the various details and scope of the proposed rule, the reasons behind non-competes, and the potential legal challenges to any final rule that the FTC may issue. Joining me today is my co-host, Elyse Dorsey. Hi, Elyse.
Hey, Anna.
Would you like to introduce our guest?
I would love to. Our guest today, as you said, is Anna Aryankalayil. She is currently a partner at Orrick, Herrington, and Sutcliffe's Washington, D.C. office. She was a former attorney advisor to FTC Commissioner Noah Phillips, and she's now back in private practice, counseling companies in tech, life sciences, and the energy sectors on all sorts of antitrust issues, from M&A clearance and litigation to government conduct investigations and other antitrust counseling and compliance issues. Anna also serves as a leader in the ABA's antitrust section as a vice chair of the M&A committee. And on a personal note, Anna is a former classmate of mine from law school, so I'm especially thrilled to have her today. Anna, welcome.
Thank you so much, Elyse and Jana, for having me.
Yeah, we're really excited to talk to you about this today. This is something that's, gotten a lot of press in the antitrust trades since it came out. So before we start digging in, we thought it'd be great if you could kind of start with an overview of the proposed rule and what specifically would it make illegal?
Sure, Elyse. And again, thank you for having me. It is certainly a very timely topic, as you said. So at a high level, the rule as proposed would make it illegal for employers to basically do 3 things. 1, enter into or try to enter into a non-compete. 2, keep an existing non-compete that they already have, because the rule as proposed would require employers to rescind any existing non-competes and actively inform workers that they are no longer in effect. And finally, the proposed rule would make it illegal for employers to suggest to workers that they are subject to a non-compete restriction when the employer has no good faith basis to believe that the worker is subject to an enforceable non-compete. And I'll say this is a pretty big deal. Non-compete agreements are common across all types of businesses. So a federal ban on non-competes going forward, not to mention invalidating all existing agreements, would be a pretty seismic shift in the employment landscape.
Thanks for that overview. So we noted that the FTC also recognized some exceptions to that proposed rule, right? Can you tell us what those are and what that means?
Sure. The rule as proposed recognizes 3 exceptions. First are other types of restrictive covenants, such as non-disclosure and customer solicitation agreements. There is a caveat: unless those agreements are so broad in scope that they in effect function as non-competes. The second exception is non-competes that are entered into outside of the employment relationship. So The example in the NPRM is the context of a franchisee-franchisor relationship. And the final exception is non-competes that are entered in connection with the sale of a business. There's, again, a caveat here that is the individual who is restricted by the non-compete is an owner or partner in the business with at least a 25% ownership interest in the business being sold. There are, of course, also some exemptions to the FTC Act itself. For example, nonprofits, the common example is nonprofit hospitals or telecom companies under the common carrier exemption. But setting those aside, the FTC has jurisdiction over most of the U.S. economy. So the scope of the rule as proposed would be quite broad.
Yeah, I think the kind of broad sweeping nature is something that's come up a lot in this discussion. And one thing in particular is that this rule would purport to ban all non-compete agreements across, wage earners, essentially, right? So low income earners, high income earners, there's no distinction between the two. Why is that noteworthy?
Yeah, that's right. It's noteworthy and it's quite significant because the rule would cover contractors, gig workers, paid and unpaid workers, interns, really anyone who has an employment relationship with a business would be covered. I think that caught people off guard because most people were expecting the rule or the ban to be limited to perhaps lower wage employees. And I think that is perhaps an area where there is much more consensus and economic learning to perhaps support a policy like that. You mentioned in the intro that it's interesting that non-competes even made it into the president's State of the Union speech recently. Although I saw that he was getting fact-checked on Twitter and other social media right away, because I think he was speaking specifically about low-wage workers in the speech. I think he said fast food restaurants are requiring their employees to sign non-competes. But line employees at fast food restaurants are not the people who are typically subject to a non-compete or against whom non-competes are enforced. Non-competes are often associated with high-wage executives, for example, with access to trade secrets, confidential business information, things like that. And there are legitimate business interests in protecting that information. So I think that's why the broad sweeping nature of the ban has caught folks off guard.
Right. And with the executives and their compensation, a lot of times the non-competes are negotiated very heavily, right? And so when you're retroactively banning them, there's not necessarily a mechanism to go back to the bargaining table.
Exactly. That's right.
And so I guess with that leads us to the next question of why now, right? Non-competes have been around for such a long time without the FTC stepping in. I think we have more than a century of legal precedent on this. So what do you think is driving the timing of the rule? And on the other side, what are some of the reasons that non-competes have been in place for so long?
Yeah, so you're right that non-competes have existed in common law for actually hundreds of years. I think I read recently that they've been around since the Middle Ages. So they've certainly existed here in this country since the founding. And under the common law, how we determine whether a non-compete is enforceable or not is you conduct a fact-specific inquiry into whether a non-compete is unreasonable in duration and geography and scope, taking into consideration the business justifications for that restriction. So, in terms of why now, I think folks are aware that there was an executive order the president put out back in July 2021 on promoting competition, and it called for a whole of government approach. And one of the line items in that executive order was for the FTC to ban or severely limit the use of non-competes. And the antitrust agencies, the U.S. antitrust agencies recently have been very focused on issues related to unequal bargaining power. Now, to your point earlier, if a business signs a non-compete with a high-level executive that is heavily negotiated, then those arguments of unequal bargaining power may not hold. But, we see this in other areas of antitrust enforcement, for example, with the focus on labor issues. There's also has been a focus with the agencies on innovation. And the line of thought here is that non-competes might hurt innovation by stopping the flow of ideas and people and therefore the creation of competitive startups. Now, we talked about, in the common law, you conduct a fact-specific inquiry into a non-compete with the business purposes in mind. And, seeing the lines of argument on innovation reminds me of one of the critical pro-competitive justifications for non-competes, and that is simply that companies use non-competes to protect their intellectual capital. It's a critical tool for protecting trade secrets. Now, there are trade secret laws, but sometimes NDAs are arguably a less effective alternative because many times a company will never find out about a leak until it's too late. So, just to more concretely put what might be the business justification. So, for example, if a business wants to invest in R&D to create a new product, but can't prevent employees with critical knowledge of that product from starting their own competing firm or taking the knowledge to a competitor, that initiative may not be economically viable for that business. So without a non-compete, many businesses wouldn't be willing to take on that risk. So, it follows then that those jobs, those innovative new products, those resulting benefits to consumers would never be realized. One of the things the FTC points to say you can mitigate this ban on non-competes and still protect your trade secrets is they're pointing to the trade secret laws. So what we're going to see is a jump in trade secret claims, right? And that's certainly going to increase costs and legal certainty for businesses.
Yeah, I think that's, a really good point is, what else are we going to see in terms of how employers react and how they try and protect that kind of information? And I suspect a big part of what employers are generally concerned about is, not necessarily employees going and deliberately leaking secrets to new employers, but, just you've gained a certain amount of know-how and things that you might not realize are, specific to the company until you start sharing them. So I think there's a little bit, of that kind of, does a per se rule banning non-competes? Again, when the history with non-competes has been to say, okay, are they justifiable? Are they short in duration? Like, what's the scope? Are they preventing someone from ever working in this field? Or is it, a limited kind of cooling off period that, would allow the company to continue to have its innovation and R&D work, because, some of this is a little more amorphous than simply saying, it's definitely covered by trade secret law or other IP protections.
Yeah, that's exactly right, Elyse. And if you look at the NPRM, the FTC asks for comments considering alternatives to a complete ban on non-competes, right? So instead of a categorical ban, the FTC could adopt a rebuttable presumption of unlawfulness. So, a non-compete would be presumptively unlawful, but it could be rebutted by showing, by meeting a certain evidentiary burden of protecting legitimate business interests, or not having the ban apply uniformly to all workers, and instead perhaps limiting this categorical ban to line employees or lower wage workers, or using some other combination of factors. So the NPRM recognizes, I think, the sweeping nature of this ban. And and recognizes the final rule might take a different look.
Yeah, and speaking of that, I want to make sure we have time to also get to this other really interesting piece of this, right? Is that this is the first time that the FTC is actually undergoing their methods of competition rulemaking, right? And we
Right.
know that they have to go through this initial comment period, and then they'll, have to take into account any significant comments before they can issue a final rule that businesses then have to comply with. And, businesses get, 180-day grace period, but we know that entire timeline could go out the window in the very likely event that business groups challenge the final rule in court, right?
Right.
And so can you cover kind of the legal obstacles that we're looking at here?
Sure. I think one thing we know for sure is that whatever form the final rule takes, it will face significant legal challenges. And as a result, may be enjoined entirely, or perhaps parts of it could be struck down. We won't know that until the final rule makes its way through the courts, but we know that it will make its way through the courts. Business groups have already said publicly that they will challenge the final rule, whatever form it might take. And as you mentioned, I think we already know some of the legal challenges that are sure to play out in litigation. First and foremost is whether the FTC even has the statutory authority to make a substantive competition rule. So this NPRM would ban non-competes as an unfair method of competition. So the NPRM points to Section 6G of the FTC Act and says, under this section of the FTC Act, the Commission is authorized to make rules and regulations for the purpose of carrying out the provisions of the subchapter. That's the text of the statute. And for decades, the agency's view, the Federal Trade Commission's own view of its powers under Section 6G, was that the agency was authorized to make procedural rules, but that it did not have substantive competition rulemaking authority. Now, to counter this, I think the FTC would point to a case from the 1970s from the DC Circuit called National Petroleum Refiners, where the court held that the FTC has the power to promulgate substantive rules. But I think it's important to note that 2 years after Petroleum Refiners, Congress passed MAGMAS, the Magnuson-Moss Act, which laid out procedures for the agency to follow when it's making consumer protection rules. So this law says absolutely nothing about substantive rulemaking for unfair methods of competition. So the uncertainty here is whether Congress was granting substantive rulemaking authority to the FTC for the first time with this law. And if a federal court concludes that it was, then the FTC was only given consumer protection rulemaking authority. It would have to follow then that it doesn't have competition rulemaking authority. So to do things like the non-compete ban, the FTC is relying on the fact that it has this competition rulemaking authority. And I know that was really in the weeds, but for anyone who took statutory interpretation in law school, the devil's in the details. And I think it's important to keep this one in mind because this is just going to be a first line of attack against this rule. The other potential legal challenges are both constitutional objections, and they would apply even if it was found that the FTC had the statutory authority to make a rule like this. And I'll go over those very briefly. First is the non-delegation doctrine, which is based on the principle that Congress cannot delegate away its legislative power to another branch of government, including independent agencies. As folks might recall from admin law, the judicial test here will be whether Congress has set out an intelligible principle. The second constitutional challenge will be under the major questions doctrine, which holds that when a federal agency exercises its statutory authority with respect to a major question, it needs clear authorization from Congress to act. So here, the threshold question is whether the ban on non-competes is a major question. And helpfully, the Supreme Court recently weighed in on major questions when it struck down an EPA regulation in West Virginia v. EPA. So in that case, Justice Gorsuch, in his concurrence, gave us some guidance on what counts as a major question. So, for example, if an agency tried to resolve what he says is a matter of great political significance, or regulate a significant portion of the U.S. economy, or intrude in an area that is the particular domain of state law, then that might be considered a major question. So applying that to the non-compete ban, some of these factors, let's take regulating a significant portion of the U.S. economy. I think the NPRM says that non-competes affect something like 30 million workers, 1 in 5 American workers. That is certainly a significant portion of the economy. Another point about intruding into an area of state law where it was predominantly the domain of state law, non-competes have developed under common law, under state law for hundreds of years. So my own view is that many of these legal challenges are likely to prevail in some form or another, especially if you look at the makeup of the current Supreme Court. And honestly, when I saw this non-compete ban came out, it reminded me in some ways of the COVID-19 vaccine mandates that were promulgated over the last few years by various federal agencies like OSHA and DHS. If you look now, those regulations were either invalidated in whole or in some part by federal courts recently. And my guess is that this rule is headed to a similar fate.
Yeah, I think that's a really good point. So a lot of the justifications I've seen from those who are proponents of the rule is that the economics is, unequivocally that non-competes are bad and that this is going to make so many people's lives better and have all of these helpful effects on innovation and allow people to move, allow the economy to be unleashed, essentially. But that does, from what you're describing, sound like it runs head into this major questions doctrine.
Right.
And and like you said as well, the courts lately have been a bit more willing than they have perhaps previously to go back and really dig into what was Congress intending, what's in the statute, and what actually is the FTC's authority in a very, you mentioned you got into the weeds a little bit earlier, but the court's shown that they've been willing to do that recently.
Yeah, that's right. And, on sort of that threshold question of does the FTC even have the authority to issue a rule like this? I mentioned the DC Circuit case, National Petroleum Refiners, which is what, the FTC is citing for its legal authority for making substantive rules. One has to ask, with the current makeup of the Supreme Court, would this court let National Petroleum Refiners stand? I think this court might be very much willing to perhaps overturn petroleum refiners. So I think it will be very interesting for us to see this play out in the federal courts, regardless of what form the final rule might take.
Yeah, it's certainly going to be an interesting time for all of us admin law nerds, right? So another big deal here is that it kind of runs straight into state and local rules, right? Because the proposed rule purports to supersede all of those rules to the extent that they're inconsistent with the FTC's rules. Can you talk to us about that dynamic?
Right. It's a really interesting dynamic because, as we've discussed, non-compete case law really developed as common law under state laws, under existing state laws. And this ban, as you said, would supersede all state laws on non-competes. And it again raises interesting constitutional questions, right? So, for example, when we think about major questions, one of the indicators that an agency is acting on a major question is if it is stepping into something that is primarily in the domain of state law. And again, that I would argue that that is exactly what non-competes are. So I think there's a lot of interesting, we talked about admin law nerds. For constitutional law nerds, there's a lot of principles of federalism that are implicated by this. And it'll be interesting to see what the courts do with this.
For sure. And as you mentioned too, this is still only a proposed rule, and the FTC specifically, asked some questions about scope and other ways it might be tailored. So what are your expectations as to whether this rule ultimately gets adopted in a form that looks like it does today? Do you think there are going to be any sort of major or minor changes that might help it avoid some of these constitutional or other questions?
So I think it will be impossible for the FTC to get away from the threshold question, right? Which is, can it even make a competition rule? Can it even promulgate a rule as a substantive competition rule? So I think it'll be impossible for the FTC to get away from that. But if the agency can sort of clear that hurdle, I think to sort of best protect the rule, or as much of the rule as possible, I would expect the agency to make some major tweaks. I don't expect the final rule to look like the proposed one, which is a blanket ban on non-competes. So, as we discussed earlier, the rule, the NPRM itself requests comments on ways to limit it. A big one is whether senior executives should be treated differently, whether the ban should only apply to, for example, low-wage workers, or whether there should be a rebuttable presumption. So it's very surprising to me that the rule that came out was a blanket ban. I think a lot of people were surprised by that. But I would expect some major tweaks along those lines in terms of a rebuttable presumption, in terms of distinguishing senior executives from other workers in a business, and even perhaps expanding the sale of business exemption as currently proposed, because there's currently a 25% threshold.
So with all that, I guess it kind of begs the question of what does this mean for employers? Like in the short term, what should they be doing, and how should they be thinking about this?
Yeah, that's a really important question, and I would say in the short term, don't panic, right? Because the proposed rule is still in the 60-day comment period, and employers would have 180 days after the date of publication of any final rule to comply. But I think, just as we were just discussing, I think it is far from clear what that final rule, if any, will look like, and whether it will even survive the inevitable legal challenges. But I do think there are some preliminary steps that employers should consider to put themselves in the best position should the final rule take effect later this year. For example, now is the time, I think, to assess the content of your existing policies and agreements with respect to post-employment restrictions to make sure they're not overbroad in duration, in geography, in scope, under existing state laws, and quite frankly, under the case law. The critical question to ask here is whether the non-competes your company uses are necessary to protect your legitimate interests. And I think you should also consider whether you can protect those interests with a less burdensome covenant. For example, a more narrowly tailored customer non-solicitation agreement, or perhaps a confidentiality provision, or NDA. But again, with these restrictive covenants, you want to make sure that they are reasonably tailored to protect to protect your legitimate business interests. But beyond those non-disclosure agreements or non-solicitation agreements, I think employers should also consider non-contractual strategies to protect their business. For example, controlling physical and electronic access to sensitive information, right? Or tweaking their recruiting and hiring practices. And I think employers can always think of, identify creative ways to incentivize employees to stick around. I think prudent employers during this time will really use this time, letting the regulatory and litigation processes play out, but, examining the full range of tools at their disposal to prevent employees from leaving in the first place. I would also add that to avoid future issues, if you wouldn't share certain confidential information with certain workers without an enforceable non-compete, you may want to consider other ways to protect that information and generally shoring up your NDAs and other restrictions. The point here is that, employers really should engage in this analysis, not only in anticipation of a final rule, but also to manage the risk of becoming the target of an investigation today. I mean, we saw that a day before it issued the NPRM, the FTC announced 3 consents, forcing 3 separate employers to drop their non-competes, I believe, against thousands of workers. So although the proposed rule is pending and we don't know what form it will take in its final form, there's no reason to believe that the FTC will take its foot off the gas on investigating and doing enforcement in this area.
Thanks so much, Anna. That's, I think, a lot to think about, a lot of really good advice in terms of, not only what to anticipate a rule might look like, what, any challenges to the rule might look like, but also some very practical guidance in terms of, okay, with all of this uncertainty the FTC has just created, how do we act in the interim?
Right. And one other thing I'll say, Elyse, is, to speak up and file a comment if you have something to say.
Yeah, that's a very good point. The FTC has been very vocal about soliciting comments and looking through the comments. I know from my time at the FTC, that's something they take very seriously and want to make sure they're wading through. And it really helps when they have, the perspective of folks who are on the ground and actually grappling with these issues.
Exactly.
Yeah, and taking a really quick peek, it looks like there are thousands of comments, a lot of them from individuals. So it'd be really important to also hear from the business community. So,
that's right.
Think about submitting a comment either in your own name or through a trade association that you're a part of, something like that.
Absolutely.
Excellent. Well, this has been, again, a great discussion on the FTC's proposed rule to ban non-competes. Before we let you go, though, we have a couple of other fun questions to help our listeners get to know you a little bit better. And the first is, what advice would you have for any young lawyers or law students?
That is an important question. First thing I would say to young lawyers, from my own experience, people are willing to give you as much responsibility as you can competently take on. So sometimes you just have to ask for the opportunities you want. And, obviously you need to set yourself up so that people are confident that you can execute and do so competently. But, whether it's taking a deposition or going to a client meeting, you might not get an invite, but, I would say just ask if you want to do it. The worst thing that can happen is a partner will say no, and that's not a big deal. But if you don't ask, the answer is always no. So I would say ask for the things that you want to do, that you want to get experience in. I'll leave that as my one advice.
No, I love that. I think that's a great point and a great piece of advice, right? Because even if that opportunity is not necessarily available immediately, it might be down the line, and then the partner or senior associate might think of you at that point, right?
So I think exactly. And honestly, sometimes the partner or senior associate they're not thinking about that opportunity. It's not that they're trying to keep you out of it or, not get you that experience. It just hasn't crossed their mind. So I think it's on young lawyers to speak up and ask for the experience or experiences that they want and put themselves out there.
Yeah, be proactive. That's great. So flipping from the professional to the personal, tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
Well, that is a fun question. So I love to travel. And one of the things before I came to my current firm was I took about 6 weeks off after I left the FTC, and I traveled. So I went to, I went to Lisbon, Rome, Hawaii, and Vegas during my time off. And a lot of people said, did you just throw darts on a map? Because those are completely random places. No, I didn't quite throw darts, but I love to travel, and I was very grateful to be able to take that time off and get some good travel time in. And I guess just another piece of general advice is, you can't always do this, but if you're, between jobs, that's the best time. Just unplug, take time off. I didn't do this before I started my job at the FTC, so I really made up for it when I left.
You did. Yeah, you did such a great job. I'm always impressed, Anna, when I hear you talk about that. I think that's like the best use of time off that I've heard from anyone. So I might come to you next time I'm in between jobs.
Oh, please do. I'll give you lots of travel recommendations.
All right. We will look forward to it. Well, thanks so much again, Anna. This has been a great discussion, and we hope to see you next time.
Thank you so much. It was my absolute pleasure to join you guys.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.